Hello and Assalamualaikum. Today I'm going to present about the terms and condition of collective agreement that I found to be much more beneficial than Employment Act provision. My name is Sofiah binti Ainol Azam. My matric number is 193418. Firstly, I'm going to show you a video that will explain briefly on what is collective agreement.
The collective agreement. We hear the term all the time, but what exactly does it mean, and what responsibility does the union steward have when it comes to a collective agreement? A collective agreement is very similar to a rule book, one that spells out the conditions of work so that the rules apply to everyone. If you talk to anyone who has no collective agreement, for example, you'll soon hear a litany of complaints. Different pay rates for the same job, fewer benefits, no job protection, the list goes on and on. A collective agreement prevents this because it specifies clearly the terms and conditions of work. And because your union and the employer have signed it, it's binding. No excuses. And there's a grievance procedure to make sure it's enforced. What are the specifics of a collective agreement? A collective agreement will spell out the hours of work. It will specify when overtime pay kicks in, how much vacation one gets, and how vacations increase with years of service. It will detail what the employer pays toward health plans, pensions, and other benefits. It will have rules for posting job vacancies and criteria that help plan one's career path. It may spell out mileage rates or training allowances. And it will recognize your union rep or steward as the person authorized to speak up for you to your supervisors without being accused of insubordination. Remember, these are not privileges. They're your rights as a worker. So what's the steward's role in all this? Be familiar with the collective agreement, be able to interpret it, and see that it's enforced.
Next, I will show you another video that provides a little bit background of Employment Act and some other issue of it. Let's check it out.
The Employment Act is scheduled to be amended in Parliament soon. Here's why you need to know about it. The Employment Act sets out the minimum terms and conditions in the employment of workers. It covers working hours, leave, and protects income security and indiscriminate firing. Basically, it's supposed to be a law that protects the rights of workers, but only low-wage or blue-collar workers. The Act only covers those earning below 2,000 ringgit or those engaged in manual work and domestic work. And we really need these protections. In 2014, a global study ranked Malaysia as one of the 24 worst countries for workers. We haven't improved much since. In 2018, the study noted that Malaysian workers faced systematic violation of rights. Research shows that Malaysian workers work on average 15 hours per week of overtime. Over half are at risk of mental health problems, while 12% actually suffer depression. If you're female, things get worse. You're much less likely to ever get a managerial job. And if you're pregnant, you stand a 40% chance of having a job application rejected, just because you're pregnant. Meanwhile, depending on the sector, you'll be earning up to a third less than your male counterparts. And don't get me started on this. We might not notice it because we're living in it, but the Malaysian workplace is far from ideal.
Through the video, it implies that Employment Act are not as good as it seems. And that's why this topic will further give reason on why other terms and conditions like collective agreement that actually will bring more benefits than Employment Act. Next, we continue with the collective agreement that I found in the Putra Blast, in which Dr. shared before, and there are actually 4 different types of collective agreement with 4 different companies, but among those 4 I decided to choose the Textile Pakaian Johor in 2015 because I think this document is easy more to be compared with the Employment Act. And the Employment Act, as usual, I found it on Google, and it explained about the laws of Malaysia in terms of the EA itself. So now we can continue to um, look at the differences between the CA of Textile Pakaian Johor 2015 and EA. The first differences that I found between collective agreement in Textile Pakaian Johor and Employment Act 1955 is in terms of the pilgrimage leave. For those who don't know, pilgrimage leave is the day of being given, especially for the Muslim employee that wish to go to the Mecca in order for them to perform Umrah or Haji. So the differences is that in collective agreement, the employees wants for those who have served the company for 5 years and aged above 45 years old may apply for this leave. And pilgrimage leave shall be granted to the exigencies of the service and shall be granted only once during the employee tenure of service, and it will be granted up to the maximum of 40 calendar days. And the quantum of pilgrimage leave to be applied for shall comprise of 75% of accumulated leave and 25% of unpaid leave. In contrast to that, Employment Act did not mention anything to give pilgrimage leave specifically for any Muslim workers or employee. So for the second differences that I found is in terms of the working hours. Okay, so for CA, they demand for Muslim male employees to be given time off for Friday prayers as follow, which is that for regular hours employee, lunch and prayer break time on Friday will be from 12:30 p.m. until 2:30 p.m. or even earlier. And for rotation shift employees, time off for Friday prayer shall be taken only when working the second shift, when employee shall report for the work at or before 2:30 p.m. And for EA, unfortunately, there is no specific rule that implies for Muslim male employees to have special working hours during Fridays for Friday's prayer. Alright, so next is the differences in terms of allowance. For CA, the employee demands 5 different types of allowance to be given to them. The first one is attendance allowance, which means that if the employee have great or full attendance, then they will get allowance. And the second one is the transport allowance, which means that if the employee wants to go to work using any transport, they will be given allowance. And the third one is special relief allowance, which means that under certain cases, like if employee are working from home during the COVID-19 crisis, then they will get allowance. And the fourth one is shift allowance, which means that the employee that are working on shift, they will get allowance. And the final one is the outstation allowance, which means that if employee are working outside from the company, then they will get allowance. For EA, I did not found any attendance, transport, special relief, shift, and outstation allowance for to be agreed between employer and employee. And the only allowance that I found in EA is the maternity allowance. So the difference between public holiday in CA and EA is that the collective agreement, the employee wants the company to give a total of 16 public holiday per year. And for Employment Act, there's only 11 days of the gazetted public holidays will be given to the employee. If you look at the collective agreement, the differences is that for Hari Raya Puasa, they want 3 days off. But for EA, they will be given only 1 day off for Hari Raya Puasa. And the second one is that in Chinese New Year, they want 3 days off for CA. And in the EA, they will be given only 2 days off for the celebration. There is also differences in terms of annual leave.
In CA, the employees want to be granted annual leave after having completed 1 year of service as follows. So the first category is that if the employee works for 1 year but less than 2 years, they will get 10 days of annual leave. However, in Employment Act, it's already been decided that for this category that they will only get 8 days of annual leave. And for second category is that if the employee works for 2 years or less than 5 years, they will get 15 days of annual leave. But for Employment Act, they will only be given 12 days of annual leave. And the third category is that if the employee works for 5 years but less than 15 years, they will get 20 days of annual leave. But in Employment Act, it has been decided that they will only get 16 days of annual leave. And the fourth category is that if the employee works for 15 years and above, they will get 23 working days of annual leave. And there's no annual leave being decided for this category for Employment Act. For the differences for prolonged illness and disablement, in collective agreement, the employee wants the company to continue considering the cases of TB, cancer, and leukemia on individual merit. And the company should also provide alternative employment or another types of work to the employee that suffer disablement due to the illness or any kind of accident. And where alternative employment is provided, the terms and conditions shall be in accordance with the grade in which such alternative employment is categorized. For Employment Act, they did not mention anything to provide other employment if the employee falls under this category of disablement. They only state that such person or such employee will be receiving pay compensation under the Workmen Compensation Act 1952 or any periodical payments for temporary disablement under the Employees Social Security Act 1969. The last differences is for bonus. In collective agreement, the bonus shall be paid during the year that ends 31st December, provided the employee does not resign or be dismissed on or before 25th December of the bonus year. And the quantum payment shall be as follows, which is that for peace-rated employee, if they perform service up to 6 months or less than 1 year, they will get a bonus quantum of 450 ringgit. And for monthly rated employee, they will get 50% of the last drawn monthly basic salary. And for peace rated employees that perform service 1 year and above, they will get bonus equivalent to 1 month average basic wage based on 11 months earning or minimum 900 ringgit, whichever is greater. And for monthly rated employee, they will get 1 month last drawn basic salary. So for Employment Act, they only mention about the terms and condition for wages, and unfortunately wages does not include bonus as a part of it.
In conclusion, it can be said that collective agreements are indeed more beneficial than Employment Act. To end my presentation, I will leave a final video about some suggestion of changes in Employment Act that might need to be done in order to improve the Act itself. Last but not least, I would like to say thank you for watching. Have a nice day ahead. Thank you.
Here are 7 key proposed amendments to the law suggested by all of these guys. Yeah, a lot of people want these changes. First, the act should cover all workers. Everyone, no matter the salary, should get the same protections. With cost of living soaring while wages stay stagnant, even those who earn above 2,000 ringgit need employment protection. Second, a reduce in working hours from 48 to 40 hours a week. And that's not just a populist move. Studies have shown that working hours has little to no impact on productivity. Maternal leave. All employers to be required to offer 98 days paid maternity leave, up from the current 60 days. After all, labor is hard work. Number 4, No more manpower outsourcing. Outsourcing allows employers to treat workers in full-time roles like temp workers, which means they don't get benefits and can be fired at any time. Number 5. Make discrimination illegal. This includes discrimination on race, gender, religion, language, disability, marital status, pregnancy, union membership, citizenship. 6. Stop sexual harassment by requiring all employers to have their own sexual harassment policies. 7. The act should also cover migrant workers, who are among the most exploited workers in Malaysia. They must have the same protections and right to redress as local workers.